We're here today to talk about data protection and how it's being used as a tool for reputation management claims. It's something that's a big topic of conversation in media law sectors. So Patrick, are you really seeing data protection used as a substitute for libel claims? What does that look like?
I mean, we see, I don't know if substitute is necessarily the right word, but I do think data protection can supplement essentially libel claims. So we see data subject access requests, which is an opportunity for claimants to get a hold of pre-disclosure information and is used as a sort of fishing exercise really to see essentially if there is anything that will strengthen a potential claim that they might bring. You've also got an interesting area. One of the principles of data protection is that personal data should be accurate and up to date. Now that sounds as if, make sure someone's name, address and contact details are up to date. But it also should not be inaccurate. And in the Data Protection Act 2018, it talks about inaccurate as being incorrect or misleading, which is actually much closer to sort of libel than it is to your contact details being up to date. So you can see there that actually if you are publishing misleading information, then immediately they potentially could bring a claim under breach of the accuracy principle. And then you kind of have pretty similar, as I understand it anyway, remedies that you would do for libel. So you've got your kind of rectification and your erasure.
Yeah. So I think you make a really good point about the way in which data protection sort of winds into the world of reputation management and where it can be used by people as tools in reputation management. But I think it is worth thinking about what the differences are and where they benefit each other. I think procedurally, which is what litigators are always harping on about and nobody really wants to listen to, you've got things like the burden of proof in particular in a data protection claim is different to the burden of proof in a libel claim, right? So the data proof in a data protection claim is it's on the claimant to prove that the information that was published was inaccurate, whereas in a libel claim, the burden of proof is on the defendant to prove that it was in fact true. And so you can see a world in which a claimant would think this is not very appealing for me to have to bring a claim here because then it's on me to try to prove that it was wrong. And that's really a pretty major procedural difference between the two. But the remedies are largely the same between the two. I think one of the big difference from remedies is an injunction beforehand. So if somebody wants to get an injunction beforehand in libel, it's not, the case law says it's not really available to you to have an injunction for a defamatory statement, but you could potentially get an injunction to prevent publication in data protection beforehand. So that makes it slightly more appealing. And then there's the statute of limitations. And what we see in media litigation quite often is that people are largely bringing data protection claims on their own for reputation management because they've just missed the boat on a libel claim. A libel claim only has a 12-month statute of limitations, but data protection, obviously, you've got 6 years. So I think that's, procedurally, those are all the considerations that are going through the head of a claimant when they're deciding how they want to manage their reputation. But do you think there's any real substantive difference between the two?
I don't know if it's necessarily substantive differences, but clearly you can see that it's going to turn the heat up on the defendant, right? So you've got, you're facing libel proceedings, and then on top of that, you get data protection proceedings. Maybe they're connected with the DSAR and a failure to respond to it properly. Maybe they're connected with the underlying processing of personal data. But you're there, additional tools, additional leverage, more claim forms, threats, to bring more DSARs, threats to complain to the ICO. You can see that for a defendant, it's going to essentially, I guess, turn up the heat.
Except for the fact that obviously the damages awards that are being awarded in a data protection claim tend to be a lot lower than those awarded in libel claims. So you sort of have a bit of both worlds to be considering. It does turn up the heat, but also there's not as necessarily as much to gain.
And you don't necessarily have as high damages, although you do have this kind of, I guess, wonderful thing in data protection where you can bring a claim for distress without necessarily showing financial loss. So that perhaps brings, an entire different head of claim or sort of head of loss that you can try to bring a claim under on that basis.
And that's something that we're paying really close attention to, and it's something that's sort of been attracting attention to everybody, certainly in the media bar, about how far is this going to go? How far can distress be claimed, and what qualifies as distress? So it's something that we're acutely aware of at the moment, I think.
Absolutely, and yet we don't really know an awful lot about it, so please don't put me on the spot.
how are you advising them to deal with these kinds of data protection claims?
So, I mean, the main thing is, of course, get your house in order in terms of data protection. There's this sort of misconception in the publishing world that there is a journalism exemption in data protection, and therefore, because of that, you don't need to comply with data protection, you don't need to comply with the UK GDPR, which is not right. If your publishing purpose is incompatible with data protection, then it may apply. But because of that actual test, what we advise is that people think about their processing, think about what they're collecting, think about how they're using it, and make sure all the staff and everyone understands the expectations on them. And that's the only real way to actually help yourself, and protect yourself if people start to bring data protection claims in addition to sort of libel proceedings. But of course, they should call us.
Yes, of course, obviously they should call us. Because the truth is that there's nuance there, and we certainly get it a lot with a lot of our publishing clients who have heard a lot about, well, if we only qualify for the journalism exemption if we're publishing in the public interest, and we're not exactly the sort of highest brow, journalism, and so does that mean that we have to, stop printing, and what do we do? And I think there is some nuance there, and there's nuance around whether there's still public interest in actually publishing and just engaging in freedom of expression. But that's why you do need to make sure that you are getting the right legal advice.
Definitely. Thanks, Adelaide. That was great. And of course, look, if you do have any questions about data protection or about libel or anything like that, please get in touch with me or Adelaide or visit the Wigan website.